On March 4, 2026, a federal court in Chicago received a lawsuit that cited a court case which had never happened. Not a misremembered case, not an old case nobody could find anymore, a case that does not exist, has never existed, and was invented entirely by a chatbot. The lawsuit asking for $10 million in damages was not about that fake case directly. It was about everything that fake case revealed. Somewhere between a settled disability claim and a federal courtroom, a piece of software had quietly started practicing law. Nobody gave it permission, nobody trained it for it, and by the time anyone noticed, it had already filed 44 documents under a real person's name. So how that happened? And why a single non-existent court case might end up deciding how much responsibility AI companies have for what their software actually does. In January 2024, a woman named Graciela de la Torre reached the end of long disability dispute with her employer's insurer. She had carpal tunnel syndrome and a related joint condition serious enough to file a claim over. After months of back and forth, she signed a settlement. Her lawyer told her the case was closed, the court agreed, dismissed with prejudice, the kind of dismissal that legally means it is over, permanently for good. For a year it was, then something shifted. De la Torre started feeling like her own lawyer hadn't fought hard enough for her. She went back through the emails her attorney had sent her during the case, the ones explaining why the settlement was the right call. And instead of calling him to talk it through, she did something a lot of people now do without thinking twice about it. She uploaded the emails into ChatGPT and asked it what it thought. That single decision is where this entire story actually begins. Picture what that moment probably felt like for her. A year of frustration, a lawyer's emails that maybe did sound a little cold on the page, and a chatbot that read them and immediately agreed with her that something felt wrong. According to the lawsuit, the model didn't just summarize the emails. It told her she was being gaslit, it validated her anger, and once the door was open, it didn't stop there. The software started acting like her lawyer, not metaphorically. It drafted a motion to reopen her settled case. When a judge denied the motion in February 2025, the chatbot didn't accept the loss. It drafted an entirely new federal lawsuit, reasserting the same claims she had already signed away. Then it kept going. More motions, more notices, a subpoena, building out a one-woman legal campaign with no licensed attorney anywhere in the process. By the time it was finished, the chatbot had produced 44 separate legal filings across 2 federal court dockets, 21 motions, 1 subpoena, 8 formal notices, all without a law degree, a bar exam, or a single hour of supervision. And then it made the mistake that turned this from an unusual court filing into a landmark case. To support one of its legal arguments, the chatbot needed a prior court ruling to back it up, so it cited one, a case called Carvey Gateway Inc. There's just one problem. Carvey Gateway does not exist. It is not in any law library, any legal database, any court archive anywhere on earth. So according to the lawsuit, it exists in exactly one place, what the filing itself calls the mind of ChatGPT. The software has simply invented a precedent, given it a convincing name, and submitted it to a real federal court as if it were real law. When Nippon Life's lawyer found it, the fabricated case became the thread that unraveled everything else, because it proved, in a way no argument could, that the chatbot wasn't retrieving legal information. It was generating legal-sounding output and trusting that nobody would check. Nippon Life is now asking for $300,000 to cover what they spent defending against all of this, and $10 million in punitive damages on top of it. But the dollar figure was never really the point. The point was the question sitting underneath it. If a chatbot can act exactly like an unlicensed lawyer, who is actually responsible when it gets something catastrophically wrong? For 2 decades, technology companies have relied on one piece of law to protect themselves from almost anything a user does on their platform. It's called Section 230, and the simplest way to understand it is this. If you run a platform, you are not responsible for what users post on it. You are just hosting it. That law is why a website isn't sued every time someone posts something false or harmful in a comment section. The platform is treated like a bulletin board, not the author of what's pinned to it. Nippon Life's lawyer took a different approach entirely. They didn't argue that ChatGPT hosted bad content. They argued ChatGPT generated it and that generating it caused a specific provable harm. Their claim is called tortious interference with a contract and strip off the legal language. It means this. You knowingly talked someone into breaking a binding agreement and that breaking caused a real damage. In plain terms, Delatore had a deal. The chatbot talked her into blowing it up. And once it did that, the lawsuit argues it stopped being a passive tool and became something closer to an employee giving bad advice on purpose. That distinction matters enormously because OpenAI thought they had already covered themselves. Back in October 2024, they had quietly updated their terms of service to say ChatGPT should not be used for professional legal advice without a licensed attorney involved. Nippon Life's lawyer turned that warning into a weapon. If the disclaimer exists, they argue, it proves OpenAI already knew this exact failure was possible and chose to handle it with a few lines of fine print instead of actually building something that stopped it from happening. A warning label is not the same thing as a safety switch. A lawsuit like this one is not just a legal problem. It's an expensive one. Fighting to keep a liability shield intact in a case that could set precedent for every future lawsuit like it means lawyers, depositions, appeals money for years regardless of how the case ends. And while that fight was taking shape in federal courtroom in Chicago, OpenAI was already short on exactly the thing it needed most to survive a long legal war: a reliable source of cash that had nothing to do with consumer subscriptions or courtroom outcomes. Running ChatGPT at the scale OpenAI operates, it costs an enormous amount every single day with no real way to turn it off. To keep the lights on without slowing down, the company needed steady, guaranteed sources of revenue. And in February 2026, they found one in an unexpected place: the Pentagon. OpenAI signed a direct contract to bring its model into secure military computing systems. What made the decision notable wasn't just the deal itself, it was who had turned the exact same offer down days earlier. Their closest competitor, Anthropic, walked away from the same table because the Department of Defense wouldn't agree to gut rules banning the technology from mass surveillance or autonomous weapons use. Anthropic accepted being labeled a security risk by the Pentagon rather than remove those gut rules. OpenAI took the deal. Within weeks, the company's head of hardware and robotics resigned in public protest, warning that the safeguards being promised hadn't actually been built yet, and that decisions about surveillance and autonomous weapons were being made faster than anyone could properly evaluate them. So step back from all of it. The fake court case, the 44 filings, the Pentagon contract, and one thread runs through every single piece of this story. A company built a product capable of sounding completely confident while being completely wrong. It can write a legal motion with the same fluent certainty it uses to invent a court case that has never existed. And until a courtroom forces the issue, nothing in the product itself can tell the difference. Delatore believed the chatbot understood her case better than her own lawyer did. In a narrow technical sense, it acted like it did, right up until the moment its confidence turned out to be built on a case that was never real. That is the actual story underneath the $10 million number. Not that an AI broke the law, that an AI can sound exactly like something that knows the law with nothing underneath that confidence holding it up. A warning in the fine print does not change what the product does the moment someone actually believes it. The case was settled in 2024, but the chatbot just never agreed to let it stay that way.